Members, officers and members of the public, welcome to this meeting of the Western Area Planning Committee. Bit of housekeeping as ever. In the event of the fire alarm going off, please find your nearest exit and make your way in an orderly fashion over to the Waitrose canopy. Could you check your phones, please? Make sure that they are either turned off or turned to silent. And can I remind members of the public that this is not a public meeting as such. We welcome your contribution when you are asked to come forward as a public speaker, but please don't try and join in the debate once we've started. Thank you very much. Moving on to the agenda then, the minutes. Councillor Ward, have you had a chance to read them tonight?
Indeed I have.
And I hope they met with your approval. They have been they've been lying on the table for half an hour before the meeting. Can I take them as a true record of the last meeting? Thank you very much. I'll sign them later. Any apologies for absence, Emma?
Yes, we have apologies from Councillors Peter Isherwood, John Fraser, Pat Frost, Jill Hargreaves, Mike Hodge, Julia Potts. Thank you.
Thank you very much. And any disclosures of interest other than the normal town council planning?
None received.
Do we have any questions from members of the public?
No, Chairman.
Peter, do we have any relevant updates?
No updates today. Thank you, Chairman.
So before we move on to the applications for planning permission, can I just introduce the officers for the webcast to make sure everyone knows who's here? We have Victoria Chulaton, Planning Officer, dealing with one of the applications. Dan Lucas from Legal Department, Peter Cleveland, Head of DC, Rachel Keller's Planning Officer, and the team leader, have I got it right this time, for Southern and Western, Louise Yandel. So thank you, officers, and thank you in advance for all the help you're going to give us this evening. So if there are any site inspections arising from this meeting, they will be held on Tuesday the 4th of July at a time that we will agree. So moving on then to the first application, A1 2017-0090, land to the west of Overwood House, Old Compton Lane, Farnham. Proposal of a dwelling and detached garage. And I gather Louise is going to start this and then Rachel is going to continue. Thank you.
Thank you, Chairman. Members will recall that this application was presented to the Planning Committee in March, and members resolved to refuse the application due to the unsustainable location, the harm to the character and appearance of the area, and the impact on the Thames Basin Heaths SPA. The refusal reasons are outlined on the screen behind the officers. Since the time of this previous resolution, the Section 106 agreement in relation to contributions to mitigate for the impact on the SPA has been completed. As such, it is therefore recommended that the third reason for refusal is withdrawn. In relation to the first two reasons for refusal, legal advice has been sought in relation to the likelihood of the appellant being awarded costs from the council if the scheme is appealed. Costs can be awarded if the council has acted unreasonably and if the unreasonable conduct has caused unnecessary or wasted expenditure. The planning practice guidance gives examples of behaviours that may be considered unreasonable, and these include preventing or delaying development which should clearly be permitted, vague, generalised or inaccurate assertions about a proposal's impact which are unsupported by any objective analysis, and persisting in objections to a scheme or elements of a scheme which an inspector has previously indicated to be acceptable. In relation to the first reason for refusal, clear findings were made by the inspector in relation to the sustainability of the location for new housing. Furthermore, the location would not be in conflict with Policy M1, which seeks to encourage higher density residential development in town centres and locations well served by public transport, and limit housing densities in locations more remote from facilities and public transport. As such, the advice from the Council's legal team is that the first reason for refusal would be indefensible at appeal. In relation to the second reason for refusal, the inspector on the previous scheme concluded that the proposal would not adversely affect the character and appearance of the locality. As the current scheme has been reduced in scale and the remaining dwelling sits on the same footprint previously considered by the inspector, the proposed reason for refusal is also considered to be unsustainable at appeal. It is noted that since the inspector's decision, the Farnham Neighbourhood Plan has been to referendum, with a majority voting to make the plan. However, the inspector considered the Farnham Neighbourhood Plan in his previous decision and found that the proposal would be in accordance with the policies in this document. The issues raised by members' proposed reason for refusal have therefore already been considered and found to be acceptable in December 2016 by the appeal inspector. There is therefore a very real and significant risk of costs if the applicant appeals the decision due to the unreasonable behaviour by the council. This is because the council will have prevented or delayed development which should clearly be permitted. The reasons for refusal include vague assertions about the proposal's impact which are unsupported by objective analysis, and finally that the council will have persisted in objecting to elements of a scheme that an inspector has previously found to be acceptable. Members should therefore make a decision this evening whether they would like to make a different resolution following this advice, or whether they wish to proceed with the previous resolution to refuse the application. I will now pass over to the Case Officer Rachel Kellis, who will give you a brief reminder of the proposed scheme and the differences between the current proposal and that which was dismissed at appeal solely on archaeological grounds. Thank you, Chairman.
Thank you. Turning to the scheme itself now, you'll see the application site outlined for you on screen. Quite faint lines here, so I'll just point out what they are. This is the application site outlined in red. And just below that, this is the blue line, which indicates further land within the applicant's ownership. The site itself, you'll see it's located to the southwest. I'll point those out again just while you can hopefully see the screen a bit better then. This is the red line here which denotes the actual application site. The plans themselves are quite faded, so it's not helping you in looking at this. But and this is the blue line, and that shows further land which is in the actual applicant's ownership below. The site itself is located to the southwest of Old Compton Lane. It comprises an area of grassland with some trees and hedge boundaries. See this here on the aerial view of the site. Zoomed out a bit further at this point. And the site previously formed part of the garden area to Overwood House. I'll take you through now a few of the site photographs where you'll see the site a bit better. This, part A, this is the entrance from Overwood Lane going into the site. Part B, you'll see the arrows on the screen just here illustrating where these photos are taken from. This is looking towards the northeast into the application site. You'll see there the tree boundaries and the sort of grassland. And C, that's a further view looking at land within the applicant's ownership. Turning now to the local plan and the Farnham Neighbourhood Plan and where this application site sits. You'll see highlighted for you on the screen in red is the Farnham Neighbourhood Plan built-up area boundary, and in black is the current 2002 boundary. You'll note there's a difference between the two, and that the application site sits there, so outside of the 2002 boundary, but within the built-up boundary, within the Farnham Neighbourhood Plan. Turning to the proposed block plan and the detail of the application proposed. Permission is sought for a 5-bedroom detached dwelling and detached garage. In comparison with the appeal scheme, this represents a reduction from two dwellings down to one in comparison with that. That's shown on the screen here. You'll see the application site had a larger site area. This is dwelling 1 and this is dwelling 2 just here. Dwelling 2 is a dwelling that's been retained and is coming forward as part of this application. Turning now to the proposed plans for the development, you'll see the proposed dwelling will be 2 stories in height, feature a combination of hipped and gabled roof designs. In terms of its measurements, it would measure 21 metres in width, 12 metres in depth, and 7.8 metres in height. Turning now to the determining issues. There's sort of 3 matters of judgment, and these relate to those reasons for refusal that were concluded on by the committee previously. Firstly, the location of development. Note that submissions in support refer to several schools in the vicinity of the property and within an acceptable walking distance. In that regard, you'll see from the previous appeal decision that concluded the site would not be isolated given its proximity to the developed area boundary, schools, station and a bus stop. In respect of the impact on the character and appearance of the area, you'll note the proposal is for a reduced number of dwellings and therefore of a lesser size and scale compared with that appeal scheme. And the appeal scheme was found acceptable by an inspector in terms of its scale, appearance and impact on the countryside. In respect of reason 3 and the effect on the Thames Basin Heaths SPA, we have now had an appropriate legal agreement which has been completed and avoids any significant effect on the SPA. You'll note you've got an additional update sheet in front of you. That follows a review of suitability of the existing site access from the County Highway Authority. You'll see that they have seen fit to recommend additional conditions and amendments to condition 4. So those are reflected for you now as additional conditions and amendments. With that in mind, the recommendation is therefore that permission be granted, subject to conditions 1 to 3 and 5 to 11 on the agenda report. Conditions 4, 12 and 13 are set out on your update sheet, and the informative set out both in the agenda report and on this update sheet. Thank you.
Thank you, Louise and Rachel. This item is subject to public speaking. So could I ask first, please, for Mr. Robin Broadway, an objector to the scheme, to speak first? I think you know the ropes, but the 4 minutes starts when you press the big button.
My name's Robin Broadway. I'm representing the residents of Old Compton Lane, many of whom are here in the gallery tonight. We're strongly opposed to this application, and so we're dismayed and disappointed to learn that the Planning Committee is to review the decision it took on March 29th. And this is despite the fact that the application has been opposed not only by the residents of the lane, but also by the Farnham Residents Association, the Farnham Society, and the Farnham Town Council. Indeed, it has been formally turned down twice already in the Waverley planning process, first by your own planning officers, second by the inspector in the appeal, and 3 times if you include the committee's decision on March 29th. Contrary to the assertions of the lawyer, there are many reasons why this application merits rejection. It's a classic case of garden grabbing. The applicants have filled in a pond and cut down trees on the site, thus chasing away the wildlife that would have prevented this project from being approved. Photographic evidence, I think, has been sent to the committee members. Please do not reward this cynical approach to environmental regulations. As you can see from the proposed block plan on the screen, the approximately 200-metre narrow drive appears to have no passing places. From whichever end you enter the drive, you cannot see what is coming in the other direction. In an emergency, supposing you have an ambulance coming in one direction, and it meets face-to-face halfway down a fire engine coming the other way. It is surely not responsible to approve a house with such poor access. Sustainability, in the sense of access to transport, schools, etc., is also a problem. The applicants note that there is a mainline station 0.7 miles from the property. This may be true as the crow flies, but the only way out of the property is 200 metres in the other direction, down the lane to the entrance with Old Compton Lane, from where it is exactly 1 mile to the station. The fact is that to live in the proposed house, the residents will have to use their cars. And this gets to the core of the complaint from residents in Old Compton Lane. This rural, single-track, winding and undulating lane already has significant traffic problems. However, the lane is attractive and is frequently used by walkers and cyclists. Therefore, any further development of the lane will negatively affect the usability and the charm of the lane, not only for the residents, but from those near and far who use the lane for their enjoyment. It's for this reason that there have been no new builds, as opposed to rebuilds and house extensions, no new builds approved in this part of Compton Lane for over 40 years. The planning record shows that there were 3 attempts and they were all rejected. If this application is approved, it might be very difficult for the planning committee to turn down other applications. It will set a very significant precedent. Thank you.
Thank you, Mr. Broadway. And can I ask Carol Stellman now, please, a supporter of the scheme, to come and speak? Once again, I'm sure you know the ropes, but your 4 minutes will start when you press the button and start to speak.
Good evening. Concern has been expressed about the sustainability of the location. The following public transport, local facilities and schools are all within easy walking distance. My information is that the station is 0.7 of a mile from the property in walking distance. If I'm incorrect in that and it's a mile, I would suggest that is still easy walking distance. Buses. There's a bus stop on Waverley Lane, which is 875 yards by road, a 10-minute walk. This stop is served by the number 47 service, which operates hourly between Aldershot and Guildford via Farnham Station, the supermarket and the town. There is another bus route on Tilford Road. The bus stop is a 17-minute walk from the property and is served by the less frequent number 16 bus, which runs between Aldershot, Rowledge and also the station, the Bourne and the town centre. Within a 20-minute walk, there's the number 19 bus between Aldershot and Hazelmere, which runs hourly. The bus stop outside of Sainsbury's, which is 1.2 miles away, serves the National Express route to Portsmouth. The town centre is 1.2 miles away, also provides a number of alternative local bus routes. In terms of facilities, there are shops 0.9 of a mile from the property following main roads and paths, i.e. not as the crow flies. There is a Sainsbury's supermarket and doctor's surgery 1.2 miles from the property, again following main road routes. There are several schools in the vicinity at both infant and junior level. St Andrew's Infant School is 1.1 miles away. This is the school to which the applicants walked their children when they lived in the property next door to the application site. South Farnham Infant School is 848 yards. St Polycarp's Primary School is 1,045 yards. South Farnham Junior School, 847 yards. Weydon Secondary School, 1.8 miles. All Hallows Secondary School, 1.7 miles. Residents of Old Compton Lane regularly walk their children to all of the above schools. The applicants, when they lived in the lane, used to walk their children to St Andrew's School, This included a walk along a circa 142-yard stretch of unclassified public road which has no pavement, but is a road frequently used by walkers, runners, dog walkers and cyclists to access the local network of paths, including the North Downs Way. It also forms part of the Sustrans cycle route. Therefore, I conclude that the site is in a sustainable location, in easy walkable access of a wide range of facilities, and I commend to you the report prepared by your professional planning and legal advisors, and also the reasoning and conclusions of the appeal inspector. Thank you.
Ms Stelman. Members, over to you. We are in a situation we have been in before many times, and it's a situation we don't like, but we do have an appeal decision. It is appended to this. I don't think we need to rehearse too much of what we said last time. We can see what the choice is before us. Councillor MacLeod.
Thank you, Chairman. I think we're being put in a very difficult position. I was one of the councillors at the previous meeting that took the decision to refuse the application, but we've now got this legal advice that essentially seems to be telling us that we have to now approve it. And I'm concerned about how this looks to the general public, to be honest, first of all, and that the general public came along, attended this meeting, they thought a decision had been made, and then they discovered later that we're being asked to rethink. And I'd like to ask the officers if this is actually a normal procedure, actually. Has it happened before, or is it something that's unique? Also, in terms of the legal advice, I'd be interested to know, was this internal legal advice, or was it external legal advice? And could we be advised how much the legal advice cost, actually? I'd just be interested to know that before I go on to say further things about the application itself.
Could I just say something first? Because we were advised very clearly last time that the previous appeal decision was material, highly material, and we took the decision to overturn the officer's recommendation. In doing that, we have to do it on planning grounds, and the decision was made to delegate to the officers, to the legal department, to the chairman and vice chairman, to come up with plausible, sustainable, rigorous reasons for refusal. The reason this has come back in is that the committee did not produce them themselves, even those people like yourself, Councillor MacLeod, who voted very strongly against it. And so, you know, we have found it difficult, if not impossible, to come up with robust decisions. So I'll send it, put it over. Is it you, Dan, who likes to?
Thank you, Chair. Yes, essentially, the advice is my advice. I was instructed by the local planning authority. As you've already heard, you looked at the planning merits. That's to say, in terms of the development plan and any material considerations, you were minded to refuse it. And those reasons for refusal were delegated, as you've already heard, to development control and legal team to come up with some reasons that could be defended at appeal. Now, the proposed reasons upon being instructed, and you must bear in mind I've been called to the bar since 2004, I'm a non-practicing barrister and I've worked at many authorities. Okay. The reasons for refusal came to me, and the planning authority wanted to look at whether or not the reasons going forwards could be sustainable at appeal. Now, the test there is essentially a different test in the sense of at appeal, you could be subject to costs. Now, you're not tasked when an application comes to you to look at the issues of costs and reasonableness in the sense of a planning appeal. In looking at those reasons for refusal, my advice, and it's essentially advice, you don't have to follow this, so there's no question of it being improper or in any way imprudent. It's simply advice. You can take it or leave it. But it's right that if I'm instructed, I provide what is a professional and rational opinion about the current situation before me in looking at the law, in looking at any PPGs, in looking at any previous inspectors' decisions, and anything in the round. Now, the advice there was my advice. So in terms of did it cost anything? No. Essentially, I'm employed by the council to do a job. That was my job. So the test before you tonight is, in terms of the planning merits and the reasons that are before you currently, are those reasons justifiable at appeal without the risk of costs? My advice is you are at risk, essentially for the reasons outlined in the report, in the sense of there is perhaps a prevarication of development that should be permitted is the key one, I would say, in this particular sense. So to answer your question, Councillor, no, it's not improper. It's essentially I was instructed and I advised.
Just before you come back, Councillor MacLeod, we've been in this position before, not too many months ago, in a development on Shepherd and Flock roundabout, exactly the same. None of us wanted to permit the development, but the inspector had been very clear that a development of one house was acceptable on that site. And we had to take the difficult decision, much as nobody on the committee wanted it, was that we had little choice. And so, you know, we are, as Dan has just said, we're perfectly free to stick with our original decision. Personally, I'll say careless, that's an awful phrase. What worries me more than costs is our behaviour as a reasonable authority. I think actually that is more damaging to me than the question of whether or not we lose costs at the odd appeal. Sorry, Councillor MacLeod, you...
Thank you, Chairman. Can I say, first of all, that I accept your initial comment that myself and the other councillors who had voted against, we didn't do particularly well in coming up with reasons. I accept that point. And I wouldn't suggest for 1 minute that there's any underhand or improper. And I'm sure you're giving professional advice, so I want to make that absolutely clear. My concern is still how it looks to the general public, and that I don't know if in the case the chairman referred to, if the application come back to a second meeting, but I can tell you that the general public, and they're my constituents, if you like, they are very unhappy to see what they think is a decision taken, and then they have to come back and hear that we're being asked to think again. And also they were a little bit unhappy that there was a stumble too in the middle where we didn't give enough notice on an attempt to bring it back, and we had to defer it. So I don't think there's any point in saying any more about that. I've registered my concern about that, and I think the other part of that concern, it looks to the general public or to the residents to a degree as if our big concern is the cost to the council, rather than, you know, the decision that we're taking. You know, the chairman's putting it there. We've got to seem to be behaving properly, and she's coming from the point of view that we've got to do the right thing, regardless if it's difficult, and I can understand that point. But looking at the other way around, the way that we're viewed as possibly being more concerned about the cost of the appeal, and this is a single house appeal. Actually, it's not going to be a long inquiry or anything like that. But
I'm going to stop you, Councillor MacLeod, because you are rambling just a bit. The fact remains that at the previous time, can you turn your mic off, please?
Sorry, sure.
At the previous, when we had the same situation, the previous one, we went with the officer's recommendation. We didn't delegate the decision making and the reasons for it to the chairman and to the officers. That's what we did at the last meeting on this application, because the committee couldn't come up with their own reasons for refusing it. And one of the reasons is it's very difficult to find reasons. And so the two things are not identical. They're identical in the situation that we had an appeal. We've got another one coming up later on in the agenda. The inspector has already made a decision. Do we have, or should we, be going against the inspectors? The choice is yours, as Dan says. Nobody is saying which way the committee has to go tonight, but you have to have reasons. That's all we're saying. Councillor Lear.
Thank you, Chairman. Well, I have seen this before, and this sits with a very heavy heart with me, because I'm not at all afraid to go to appeal. I'm really not, and I've said that before in the Chamber, if I think something's inappropriate, and I do think this is inappropriate. But this application isn't a case of going to appeal because it's been. And this is where it sits with me. It's a bit of a Hobson's choice, because we're told, you know, the inspector made concrete findings in terms of character and appearance, location and sustainability. So we've taken advice on that, and I'm not at all surprised to hear the advice that's been given. We're going to lose this at appeal. So it's not a case of going to appeal and hoping we win. We will lose the appeal on this one, and that's clear. We also stand a very high chance of being given costs against us, which I think is, again, I don't like the application, but again, that's staring me in the face. So either we go against the advice and we lose appeal, and we run the risk, as the chairman says, of looking like idiots. at the inspectorate, or we support the recommendation, which for me would be the wrong thing to do for the people who live in that area, because I just think it's a wrong and inappropriate application. But on balance, and this is on balance, as I say, is a Hobson's choice. I have no choice. My hands are tied. Thank you, Chairman.
Thank you, Councillor. Councillor Story?
Thank you very much. I wasn't here for the previous discussion because I was in hospital. However, I have read this thoroughly, and it seems to me that the application effectively, the only difference between this and the one which went to appeal is that this is a single house on a smaller area, and that therefore all of the considerations by the planning inspector at appeal for the first proposal are still valid, and that we would be seen to be unreasonable to go against that. Whether or not the unreasonableness costs us money in terms of charges, I think it's more, as you said, to do with our credibility as a planning authority. If I would have been appalled, if I was here in March, I would have been appalled at a decision being made to let this go out of this chamber without having valid reasons put against it for the decision that was made. I simply can't believe that the chairman, previous chairman of this committee, would have allowed that to have happened. I'm sorry, but regardless of the merits of this house, and I'm afraid the public feeling about it, the planning inspector has taken this decision, and I must go along with it.
Thank you, Councillor Story. Councillor Nazir? Anybody else? Councillor Hyman?
Thank you. Thank you, Chairman. I was at the previous meeting, and I did give what I considered to be solid evidence-based reasons for refusal which weren't included. I was disappointed. I mean, if I read from the documentation which we're given when we join planning committees, which is called Probity in Planning, which I'm sure everybody here knows off by heart, I'd forgotten that it says pressure should never be put on officers to go away and sort out the planning reasons, and I'm surprised actually that that is the way that it worked, because I thought that we did have good reasons, which I'm not going to go into great detail all over again, because they are the legal reasons in respect of having no appropriate assessment of the impact on the SBAs. Those reasons stand, and I see they weren't considered. If we look at paragraph 18 on page 46 of our papers, Madam Chairman, and other matters, the inspector made a decision which he's perfectly entitled to make, it's my understanding, but I'm sure I'll be corrected if I'm wrong, which is that if he is turning down if he's refusing consent or not allowing appeal, then he does not have to consider the habitats issues, and that's what he said. He said that on the basis of my conclusions and the main issues of this appeal, I have no reason to consider this matter further, which is what he said. So he didn't consider those issues, which were the reasons that I wished to put forward last time, but which weren't taken forward and put into the reasons for our refusal. So he didn't consider that. My understanding is that Regulation 9.5 requires we do consider that. So I will be voting against this because my reasons remain exactly the same as last time, which is this is not sustainable development in terms of paragraph 119 of the NPPF. Therefore, it is a departure. I'd like officers please to confirm that I'm correct in that this, if they would like to read paragraph 119 and confirm it. And similarly, it's contrary to paragraph 113 and the statutory instrument circular 06/2005, paragraphs 13, 20 and 21. Those are my detailed reasons. We should perhaps adjourn to debate those in detail according to the advice that we're given in this probity and planning
Right, I'm going to stop you there. You've asked for a lot of questions. I don't know whether the legal officers want to come back straight away, but I'll take Councillor Ward, I think, and then we can clarify any legal matters after that. Councillor Ward?
Thank you, Madam Chairman. Since we're having a roll call of representatives, I was not at the last meeting, but I was not visiting Council Story and Hospital. Two sort of general points which have occurred to me. Generally, when we get legal advice, we usually ask for it to be confidential, and I'm a little uncomfortable with legal advice to the committee being quite so public, because it seems to be putting us in quite a difficult position. When I sat in that chair that you so dignified occupy at the moment, I often had a feeling that we were no longer a planning committee, that we were a permit issuing authority. And this seems to be kind of what's happening at the moment. We've been effectively told to issue a permit, which I find quite uncomfortable. There is always a risk when you go to appeal of getting costs, and it is a risk which obviously we must amongst ourselves debate how serious it is. We have had a number of inspectors' decisions, and oddly enough, some of them actually contradict previous inspectors' decisions. So there is I won't say a probability, I think that's probably pushing things a little, there is a possibility that given a different inspector, we might get a different outcome. So I'm finding it very difficult to do as I'm told, but then you know that. But somehow it just doesn't seem right to appeal this. We have had cases where where inspectors have said things such as this does not create a precedent, and following inspectors have said yes it does. We've also had things where they're supposed to create a precedent and different inspectors say no it doesn't. So I'm at the moment inclined to say let's have a go and see if we get another more reasonable inspector. Thank you, Madam Chairman.
Thank you, Councillor Ward. Just to say, we were given this advice in public, as we always are, at the meeting. Orally, we were told that there was an appeal decision that was a material consideration, and we were warned at the meeting that, you know, we would perhaps leave ourselves vulnerable if we were to go against that. So this is not new advice. This is just putting it in written form for this new discussion. But I think we can sort of draw this to an end now, because we seem to get repetitive. I've got Councillor Nazir, and if anybody else wants to speak for the first time, and then we'll ask for the legal appeal.
Thank you, Madam Chairman. My heart totally goes for the local residents regarding that, and what has happened, as you've remarked about Shepherd and Flock. That is a big building. This is a single.
I'm sorry, just
are we talking about the
you're confusing it. It was exactly the same. It was permission for a house, and they came in for.
All right, I'm just getting the wrong building. But do we have any chances of this? I would like to ask the inspector to go against it or not. What does he recommend regarding it? Because I would like to go for the residents, but if we're going to change it or anything, because my fellow colleagues have just...
I'm sorry, I'm going to interrupt you there, Councillor, and say that's not a fair question of the officers. We are here to make a decision using their advice. Their advice has been very clear. But can you turn your mic off just for a second? The advice has been very clear. It was clear at the last meeting orally. It's been clear in writing in this current, and we've had two on behalf of Louise and Dan tonight 2 sets of advice. I really don't think you can ask the officers anymore. That's their advice. You're a member of the committee. You must make the decision.
But from my fellow councillors, I can't find any points where the inspector
I'm
is
sorry,
speaking.
you don't make a decision on what your fellow councillors say. You make it on the decision that you look at the facts, you hear you read the report, you hear the advice, you make a decision.
That's what I'm saying. I would go with the advice, what I've heard, but I haven't heard any points from our councillors. That's what I'm trying to say, nothing else. To prove it as a yes or no. But I'm very much with the inspectors, which what they are saying. But my heart goes for them. That's what all I'm saying, nothing else.
I think we all would support the residents. I don't think that's the issue at all. Nobody sitting in this council chamber wants to give permission for this house. That is almost a given, which is why we turned it down. But we've got to do it on reasonable planning grounds. That's the whole point. Councillor Hill?
Yes, I share everybody's feeling about the developments. I really don't like it. I really don't support it. But during the course of the meeting, I've not heard any planning reasons for not granting it. And in that respect, I feel that I don't personally have any choice other than to support it with a heavy heart.
I'll take Councillor there, then we'll eventually get round to getting the legal advice. Thanks, Councillor.
Thank you, Chairman. I'll be brief. It's legal advice, because I'm making my judgment today based on the fact that the inspector has made findings, and those findings become material considerations. So I want guidance on that, because if those are material considerations, no other inspector is likely to turn that over. So I do dispute what I've heard, because if it's material, it's material. Am I wrong? Thank you, Chairman.
Right, well, over to the legal team.
That's essentially it, Councillor. The test in law is you've got to determine applications in accordance with the development plan or other material considerations. Now, you've heard about the development plan points, the Farnham neighbourhood plan, you've heard about the built-up area boundary. One of the speakers said this was rural. Well, according to the Farnham neighbourhood plan, it's now in a built-up area, hence the Bourough. That red line, you'll see now it sits in that area. So that's the development plan considerations. In terms of other material considerations, the inspector's findings are findings, and you may recall how I said about findings of fact. He's made findings of fact in this particular case, in terms of character, appearance, street scene, in terms of impact upon highways, and movements along that particular access. That's all been made and determined by findings of fact. So they are material. They go into the cauldron, so to speak, further round for a new inspector upon appeal to consider. So he or she will look at the development plan first, and then will turn to any other material considerations. And I would suggest, and I would respectfully submit, that inspector's decision is very weighty in the sense of the findings he made upon the actual reasons that are coming forwards currently before you. Those findings have been made, and in my respectful submission, have gone. So, to all intents and purposes, it is just advice. You can ignore the advice, or you may want to come forward with other reasons, bearing in mind it was delegated to officers. Picking up on the second point, essentially, that was about it seems improper or perhaps disingenuous to put in a public report my advice. My overriding objective is to the court as a barrister, and indeed, secondly, to a client. We're not in a court forum, so it turns into a client. It's down to the client upon receipt of legal advice as to whether or not they want to waive legal professional privilege. And in this particular case, legal professional privilege was waived. The client wanted to disclose it, and that was in consultation with the chair and vice chair. So what you see is in no way disingenuous. Legal professional privilege was waived, and it's there for all to see, carte blanche. Otherwise, we're stuck between a rock and a hard place. We're being accused of perhaps being secretive or too cloak and dagger. We've gone the other way. We've gone for transparency, and yet we receive criticisms. Where does that leave us? Essentially, you're correct, though, to answer your question. Material considerations from the inspector, and in my submission, they're waiting.
And do we have any legal reply to Councillor Hyman that you haven't already given him?
Thank you, Chair. Would you mind if I pick that point up? And I won't go into the legalistic point, but it's the impact on the SPAs. And the main consideration is that the impact on the SPA for the Thames Basin Heath is specifically addressed through the Council's own adopted avoidance strategy. They've put forward a contribution in accordance with that. We've got a signed legal agreement that deals with that. And as you'll see in on page 34 of your agenda, officers confirm that an appropriate assessment is not required. Reference was then made to paragraph 119 of the MPPF, and that is clear in saying the presumption only applies if appropriate assessment required. In this case, it isn't, as confirmed in the officer's advice, and the development is in accordance effectively with the Council's own adopted avoidance strategy, which takes into account the Conservation of Habitats and Species Regulations 2010. So hopefully that's helpful. Thank you, Chairman.
Thank you, Peter. I'd like to move to the recommendation.
Point of information, if I may.
It's all right. I was going to say, don't shout me down. I have never stopped you speaking yet. It might happen. I was just going to say, so could you keep your points brief and, if possible, make them new, please?
Yes, it's not a point, Madam Mayor. It's a point of information and a sincere objection to being called disingenuous and improper. I never made any such insinuations. I merely asked whether it would be normal and this council could have its opinion in private. I strongly object to the statements which the lawyer had made, and I would like them withdrawn.
Withdrawn. Thank you.
Councillor Hyman, is yours equally as brief?
Thank you. Yes, I'd just like confirmation in that case. As it is, we're being told that an assessment is not necessary. I'd like just confirmation, please, that I'm reading the statutory instrument at Circular 06/2005 at paragraph 13 correctly when I see that it says the decision on whether an appropriate assessment is necessary should be made on a precautionary basis. And in view of the fact that we don't have the evidence from Natural England still, that we've been waiting a long time.
I'm going to stop you again, because we do have this at every meeting, and I think it's got to stop.
I think we should have an answer.
Excuse me. Either because you sort it out with the officers outside a planning meeting and don't waste the public's and our time on it, or you accept the officer's advice when you're given it, because we have this time after time at every single meeting. It's something you will have to sort out with the officers in your time, not in the committee's time, please.
Madam Chairman, may I ask the question? Because
you may ask the question if you ask it briefly and don't lecture us.
But does the section 106 satisfy the need for Wadensey evidence from paragraph 2021 of the statutory instrument, Circular 06/2005? So are we being advised that this is legally compliant? Does it satisfy the requirements?
Thank you again. We've had this every time. Is our decision making lawful? That is really basically what the question is asking.
Councillor Hyman is correct in the sense of the precautionary principle and the voluntary approach. That is a matter we have to consider in law. However, as you've already heard, the avoidance strategy was adopted by the Council. It is your avoidance strategy. It had comment and input from Natural England as the statutory consultee in that particular regards, and it was agreed. So, to all intents and purposes, the advice from the specialists and experts that deal with this particular issue is essentially that the avoidance strategy is sound in law, and behind that there are 106 agreements coming forwards all the time before this committee to offset any impact upon the special protection area, be it Thames Basin Heath or the Wealden Heaths. These come forwards all the time. This is nothing new. Now, to date, that avoidance strategy is sound. It hasn't been judicially reviewed by any party, any developer, or indeed any appellant. That avoidance strategy, therefore, is sound.
Thank you very much. That's perfectly clear. Councillor McCall, can we make you the last speaker?
Thank you, Madam Chair. Just a quick point on the merits of the application, because I spent a long time on the procedures, but I have one point on the merits of the application. It's to do with the design. I think the design of this building is extremely dull. It's not going to improve the character of the area. And I'll just refer to the NPPF statement that says, in determining applications, great weight should be given to outstanding or innovative designs which help to raise the standard of design more generally in the area. I don't think this building does that. I think it's the exact opposite of that. And I don't know if the officer would like to comment on that or whether taking that into consideration.
I have a feeling that's a tad subjective. I quite like it, but there you go. Do you want to comment on that, anybody?
The paragraph in which you're referring is paragraph 55 of the MPPF, which sets out exceptions to allowing isolated homes in the countryside. So that is only relevant where you find that the site is isolated, not where you find that the development is in a sustainable location. Thank you.
Right, can we move then to the recommendation? If you find your update sheet, because you've got on the update sheet some changes, you've got a change to one condition, condition 4, which has been strengthened, and you have 2 additional conditions. This is all to do with the entrance to both into the site, the visibility displays, and also increase safety on the actual drive into the site. So highways have been out again to add some more conditions. So given all that, there is a revised recommendation that permission be granted subject to conditions 1 to 3 and 5.11, which were in your original agenda report, and conditions 4, the revised condition 4, 12 and 13 are set out on the update sheet, and the informatives are set out both on the agenda and also as an additional informative on the update sheets. Could I see, please, all those in favour of granting permission?
1, 2, 3, 4, 5.
And all those against?
3.
Don't we have any abstentions? I can't have it. Right, permission then is granted. Moving on then to item A2, WA 2017. Just time for the clear. There'll be letters tomorrow. I think we made the right decision, hard as it is. Right, can we move on then, please, to the second item, item A2, WA 2017-0522, Farnham Town Football Club, Mead Lane in Farnham. And Victoria Chulaton is going to introduce this, please.
Thank you, Chair. This is an application for the provision of an additional temporary hard surface in addition to an existing hard standing parking area. The resulting hard surface to provide a temporary use of parking for ancillary purposes for Farnham Town Football Club. The temporary use is for a period of 3 years, and the requirement of the parking is as a result of the current car park being lost due to works at the Memorial Hall, where parking used to take place. And here we have the location plan with the hard surfacing here. Sorry, in this area here. It's a bit below the blue arrow. And we have an aerial photograph of the site. This is existing hard standing with a new hard surfacing in this area here. And we have dwellings to the north and down the east side here. Here we have the block plan. We have the original hard surfacing here and the new additional hard surfacing in black. Given the permeability and temporary nature of the proposal, it's considered that this hard surface and use is acceptable. We have some street views here. We have a view north toward West Street and a view south towards the river. The access point can be seen here on the right-hand side. This is the access into the hard surface area, going through the existing car park. And this is a view north from the hard surface area, so this is towards West Street. And this is the hard surface area itself, looking south. Determining issues. Matters of principle and technical opinion are principle of development, loss of the playing field, highway considerations. The County Highway Authority are satisfied that the vehicle movements associated with the football club could be safely managed by way of a management plan, and a condition is therefore recommended requiring the agreement of a vehicular movement management plan. We have impact on adjacent conservation area, impact on adjacent public footpath, flood risk, impact on AQMA, effect upon the SPAs and biodiversity. The matters of judgment are impact on visual amenity, impact on Farnham Green envelope. The officers consider, with regards to the green envelope, the officers consider that given the temporary nature of the development, there would be no significant permanent harm on the green envelope. And the last matter of judgment is impact on residential amenity. May I refer you to the update sheet, which refers to an additional condition regarding the use of the site. And the revised recommendation, therefore, is that permission be granted subject to conditions 1 to 6 and informatives 1 to 4 on the agenda report and the additional condition 7 on the update sheet. Thank you, Chair.
Thank you, Victoria. This is also an item that's subject to public speaking, and do we have Mr. David Harvey who objects to the application? I think you probably know the ropes as well, so your 4 minutes starts when you press the large button.
Thank you, Chair. My name is David Harvey. I live in Rowledge. Mead Lane is on my cycle route to work in Farnham. The development site is in Farnham's green envelope and is covered by Planning Policy TC10, which states that new development will be resisted. I have, however, not detected any resistance from the Planning Department, in fact quite the opposite. When I've raised the issue of TC10 with the Planning Department, my concerns have been brushed aside. I've been told that the harm in terms of the development within the green envelope should be balanced against the need for the development, which brings me to my next point. The need for the development is, as stated in the application, to provide adequate parking for 2 squads of players and officials on match days. Nowhere in the application does it state how many spaces are actually needed to accommodate 2 squads and officials. I suggest the current 30 spaces provides adequate parking for the stated need, and there is therefore no need for the development. Also, as the parking at the Memorial Hall will be available again in the autumn, there is absolutely no need for the proposed parking. I don't see how the very weak or non-existent need argument can be allowed to trump clear planning guidance that's stating that the development will be resisted. With regard to traffic and access, it is clear from the Highway Authority's comments that they are not impressed by the application and said they would have recommended refusal if the commercial element had not been dropped. As a frequent user of Mead Lane, I have seen firsthand the problems and potential dangers of the existing traffic using this narrow single-track road with its restricted visibility onto West Street. I have seen cars having to reverse back onto West Street. The report from the Planning Department states no specific policies in MPPF indicate that the proposal should be resisted. This is disingenuous. The word sustainable development appears 60 times in MPPF's 65 pages and includes the statement that sustainable development should be seen, and I quote, as a golden thread running through both plan making and decision taking. By its very nature, a temporary car park cannot be sustainable, as it cannot provide a better quality of life or satisfy needs in the future. This is a principal test for sustainability. I urge the committee not to give undue weight to the officer's recommendation for approval. I am sure you would agree it would be very odd if they did not recommend approval for a scheme which has been funded and supported by the council. When considering the officer's advice, please remember that it is the same planning department that failed to point out that the construction would be unlawful without planning permission, and who validated the first application without a traffic assessment, which they subsequently acknowledged was in fact needed, and now turns out to be a significant consideration. On a final note, if the committee does approve the development, please can you include 2 additional conditions. Firstly, that is removed when the parking at the Memorial Hall is available again, and a condition to ensure the compliance with the non-commercial use condition, which is number 7, can be monitored, for example, by a lock gate at all times other than match days. Thank you, Chair.
Thank you, Mr. Harvey. And do we have Mr. Morgan, Michael Morgan, who's a supporter of the application? Good evening to you, and once again, 4 minutes when you press the button. Thanks.
Good evening. Thank you for the opportunity to speak in support of Farnham Town Football Club's planning application. By approving the previous planning application for the temporary changing rooms, this planning committee demonstrated their support for the club and the town to maintain the existence of our senior football club and preserve a valued community asset. My case supporting that application detailed the profound effect on the club and community should planning not have been approved. Similarly, without planning approval for the temporary car park, the club will not meet FA ground grading requirements and be unable to compete in the Combined Counties League. That consequence is made clear by Alan Constable, Combined Counties League Secretary, in his letter on behalf of the League supporting our application. I quote his words: "The provision of adequate parking facilities is a mandatory requirement of the senior level at which Farnham Town play football, as laid down by the Football Association. Without such facilities, Farnham Town Football Club would not be able to sustain senior football within the town. As the General Secretary of the Senior League in which Farnham compete, we strongly support their application." The club have been informed by Alan that the decision on this planning application must be notified to him, and our acceptance for league entry for the 2017-18 season will depend on its approval. So, unequivocally, no planning approval, no football club. It is relevant to note that prior to securing the funds and building the car park extension, we had explicit notification that planning was not required for that work. In partnership with Waverley, the project was agreed and undertaken in good faith, and the club could not have agreed to move to the temporary changing rooms without securing this essential facility to enable our continued operation. Our previous application for the temporary car park was withdrawn to give time to provide answers to a detailed range of questions posed by the Highways Authority. The transport statement provided by consultants as part of this application comprehensively answers all the questions posed by that authority. Objectors have questioned why we need additional car parking for football use, as we already have a car park with 30 spaces. League rules stipulate that 8 visiting club officials should be accommodated. Our club has the same number of officials. There are 3 match officials plus an assessor, 34 players, plus the managers, coaches and physios of the home and away clubs. And although there is some car sharing, historically a minimum of 40 spaces are required on match days. Additionally, there are 15 local residents with whom we have a long-term sponsorship arrangement which includes parking at any time, 7 days a week. This arrangement helps both the football club and the community. Therefore, to meet the total parking requirements on match days, we need at least 55 parking spaces. To summarise, we have a mandatory requirement to provide adequate match day parking. Our continued existence as a senior football club representing the town and providing a valued community asset and service is dependent on this application being approved. Our club's survival is in your hands. Thank you.
Thank you, Mr. Morgan. Perhaps just before we go to members, could the officers just answer a couple of questions that were raised by the public speakers? I'm assuming that the TC10 is much as it's put in your conclusion, that the reason this is acceptable built form in the green envelope is because it's temporary and only because it's temporary. Is that correct?
Thank you, Chairman. That's entirely correct, and that's why we've applied the condition for it to be removed after that period. Thank you.
Mr. Harvey raised the question of sort of an oversupply, if you like, when the Memorial Hall parking comes back on tap or whatever the phrase is. Is that going to happen? I mean, is it just one of those things that's so uncertain that we wouldn't be able to put it in a condition?
Thank you, Chairman. Yeah, I think you're correct. We wouldn't be able to put it in a condition. And I also think that parking is to serve the Memorial Hall uses, not the football club, so it will be effectively two separate provisions. Thank you, Chairman.
Thank you for that clarification. Members, over to you. Councillor Hyman?
Thank you. I'll kick off because I am the ward member for this, Madam Chairman. The reasons for needing this, I can't disagree with most of them. Page 56, I think they're fairly clearly stated with a number of bullet points. The club is a valuable asset. There is a need to support the local teams. It's an integral part of the community. I can't argue that the car park makes parking easier, certainly. That's, can't argue against that. And I'm not entirely certain that the survival of the club depends on achieving the FA standards. Obviously it does, but whether or not that applies in this case, because it would appear to me that the existing car park and the arrangements where obviously people are also able to use that, because the match days very rarely would coincide with use of the Memorial Hall, there is adjacent car parking. And I mean, the previous situation where the Memorial Hall parking, it will still be there, even though it wasn't football club parking before, and it won't be afterwards. I don't see why. I mean, this is about need, I think. I think we have to look at need, and the issue that I have here is that the car parking spaces that we've got at the moment, we're being told that there's a problem because there is 15 spaces used for sponsorship and whatever, and I don't think that's a planning reason we can consider. I don't think that that's something that we should take into consideration when we look at whether the existing parking is actually required or not. I do fully appreciate what was said, certainly the content of the letter from in respect of the need for parking for the Combined Counties League. Obviously we know that is, but my understanding is that the only rule is that the car parking must be adequate, and I would like some confirmation, please, that that is the only standard that is necessary at that level, because I very much understand how residents are concerned that when we've got the car park reappearing at the Memorial Hall, we're in the summer, there won't be matches during the summer. The problem that we had at the end of last year, which I think the reason this was built, was because there was a home match against Guildford in, was it October, November, and this was built a fortnight beforehand because there was no car parking at the Memorial Hall. There was certainly insufficient car parking at that point. I think, certainly Waverley would have considered so, and it was built in a hurry in order to. If you've got a Saturday afternoon home game against Guildford Town FC, then obviously there's going to be car parking problems if the Memorial Hall parking is unavailable, as it was because of the development. But I do fully understand the point that Mr. Harvey has made, that there are great concerns that this isn't actually necessary, and so I can't see why we shouldn't say this is grant a temporary permission to the end of the year until new parking is needed, and then have it returned to green space. There's no way we want to inconvenience the football club in the meantime, because if obviously there was an overrun on the Memorial Hall, there'd be a problem. But my understanding also is that we will need to appropriate the land for planning purposes for this, because in total the development on the Memorial Ground area is more than 250 square metres. So I'd like clarification. Do we have to do that before, in theory, development commences?
Right, can I stop you there, because you've asked a few questions and made quite a lot of statements.
Am I able to come back
yes,
to talk later?
Of course you can come back.
Thank you.
As long as you're not going to talk about spas and section whatevers. Can we just clarify this, the amount of parking? I mean, I'm quite happy to believe the public speaker personally, and also the question of whether we have to appropriate any land in order to accommodate this parking. Please, could you just clarify that for Mr. Hyman?
Thank you, Chairman. We've got the specific national grading category here in front of us, and it is quite open in saying there should be adequate car parking facilities on or adjacent to the ground. Car parking within the ground may not be acceptable. So that's what the category says. We've obviously got the support from the FA, locality office, apologies, specific reference to their name, chairman, sorry, stating in support of this requirement. There is a specific FA requirement for the parking provision to be next to the changing room. My understanding is that is to do with ensure the players can access the changing facilities, but also specifically referees and allowing them access. And as with the changing rooms, which the committee considered a while ago, they're also required sort of direct access to the pitch, which sits alongside this permission. Just the one point to note on the timescales and suggestion for 1 year. Obviously, we have previously considered the changing room provision, which we granted a 3-year permission for, and this sits alongside that and is required to accompany that, and it's important that the parking sits there. With regards to the specific numbers, these have been put forward by the applicant, and we've taken them on those basis. Thank you, Chairman.
Thank you. So basically, it's like any other planning matter. We are judging what is in front of us, and not here to mess around with it and tinker around and move a few things. So, did you have another point, Councillor Hyman?
In respect of your comment that that there are certain things you wouldn't wish me to talk about, can I refer to the fourth line up from the bottom on page 58, Madam Chairman? Will you see that this is actually outside of the conversation area of Farnham? Does that mean we can't talk about things? Yes, Madam Chairman. I mean, I think what I'd like to know from what you've just said is that, as you've just said, that we can only judge what is in front of us. What we have is an application for 3 years. Are you saying that if we consider that a 1 year, if we consider that the need for this is and we know that there is a need for car parking, is there possibly until the previous situation is reinstated where there is car parking for parents? I mean, if we read...
Hyman, you really do ramble when you get going on these things.
Thank you. Page 51, Madam Chairman.
I'm not going to let you ramble on. You've got to get to your points more quickly.
Page 51, Madam Chairman, states there that it's the car parking's for use for players, officials and parents on match days. I understand that that's not necessarily what the real use is going to be, and that there is no need for parking for the parents, and that...
Mr. Hyman, that is not a planning matter. We have a planning application here for a certain number of parking spaces. We have been assured by the public speaker, can you turn your microphone off, please, from the public speaker and from the officer, that this is a reasonable application. We've also been told that it would be reasonable to do the 3-year because this goes hand in hand with the application we've already granted for changing rooms. We don't just pluck these figures out of the air. There is a logic to it, and the logic is put in the reports. Occasionally we make the odd typo and it raises a laugh. But what we're looking at the moment is some parking for 3 years for a certain number of cars. Can we just stick to that? I really am not interested in who's going to be sitting in the cars and what they're going to be doing. That is not a planning matter.
Sorry, Madam Chairman, it's in the documents in front of me. Okay, if we can move to the suggestion that's made by the public speaker that we have an additional condition, which I think it was to say that we wanted to take it, just need to remind myself, compliance with condition 7. Some sort of condition 2. We've got if we're putting that condition in, the wording of that I'm not happy with. It says something along the lines of that the use of this is for use it's got the word use 3 times on the trot, and that's not normal. We would normally start with the development hereby permitted is. We'd want to change the wording of that were we going to be granting consent to it. I have found it. Additional condition 7, the use hereby permitted shall not be used for any use. That's not our normal wording, and I don't know whether
Councillor
that would
Howard, I
allow.
really am going to stop you and take Councillor Lear.
Can
We've
we
all
change
read the update sheet. I'll take Councillor Lear. If you want to come back again, come back when you've got something concise, succinct, that we can actually all understand and comment on. Councillor Lear.
Thank you, Chairman. I'll try to be as brief as possible. I'm very familiar with this site because I used to go there with my son a few years ago when it was a much smaller car park, and there were streams of cars up towards the Indian restaurant on the corner, and they were reversing out because we couldn't get in because there were no spaces. So there is a real need for this. It is retrospective, which I don't really like. Retrospective planning, I find it a bit reprehensible. However, it is retrospective. So can I ask the question, if it was built last year, and it's been in situ for 6 months already, is that 6 months out with the 3 years, i.e. 2.5 years ago, or is it 3 years from today?
Thank you, Chairman. It would be 3 years from the date of the permission granted, and that's the same approach we took with the changing rooms who have been in situ as well, so it would be from that. Thank you, Chairman.
Yeah.
Okay, on that note, thank you for clarifying that for me. It is temporary, and I think TC1 makes that quite clear, and I think you've been specific with it. So the need for me, as I've witnessed evidentially myself in the past, is such that actually this is valid. And I think with the FA's guidance, which I have got extensive knowledge of Sport England actually in other areas of the borough, I think the balance this one, the need definitely outweighs any arguments or disadvantages. So this gets my support. Thank you, Jim.
Any other councillors wish to make a comment? Councillor MacLeod?
Mr. Chairman, I don't totally understand the business about the parking at the Memorial Hall. If you can just clarify it for me. Prior to the redevelopment of the Memorial Hall, the football club used the parking at the Memorial Hall for all the purposes we're talking about now, for the officials and for the players, etc. Now, once the Memorial Hall refurbishment is finished, exactly the same parking places will be available. So why does this have to go on for 3 years? Why can't they go back to using the parking that they used before? And the second question is, what's going to happen at the end of the 3 years? I somewhat reluctantly voted for the changing rooms because, again, we're told the future of the football club was at stake, and we've been told that again now. And the football club is important, by the way. I do support the football club in the same way I would support the rugby club. Local clubs are important. But what's going to happen at the end of the 3 years in terms of these changing rooms and parking arrangements? What happens then?
Just can you answer both of Councillor MacLeod's questions, please?
Yes, thank you, Chairman. I'll pick up just on the point on the parking for the Memorial Hall. That was, as you say, originally used by a football club, and they had their changing rooms as part of that building, and they were able to park next to them, as the requirement is of the FA. See, things have changed with the redevelopment of that site. It's now got alternative uses going into that building. It's not going to be used for the football club, so they obviously can't park there and be right next to their changing rooms. So there's a requirement for the changing rooms and so the new or the temporary change rooms and the temporary car park to go in place on the other side of the pitch, as you're aware. So obviously we've got to ensure sufficient parking is available for the alternative permitted use at the Memorial Hall, as well as parking for the football pitches. There might be times where Memorial Hall might be quieter, but it has got a permitted use, and those uses could happen at the same time as a football use. The second point was...
At the end of the 3 years.
Oh, sorry, at the end of the 3 years, sorry, the football club are looking for a permanent solution to it, whether that be on the ground or elsewhere. And the reason for 3 years is allow them sufficient time to go about that process, which is not a straightforward and quick one. So that is the reason they're seeking temporary permission, so they can look for a permanent solution either on site or elsewhere. Thank you, Chairman.
Thank you, Councillor Nazir.
Thank you, Madam Chairman. A small point which Mr. Harvey said, that to put a gate so it's not misused by others. Could that be? I'm all for the application to go forward, but would you consider that for the small gate, which he's saying so it can't be misused?
Officers, have you got a reply for Councillor Nazir?
Thank you, Chairman. It ultimately will be for the football club to manage that, and if they're not complying with the requirements of the condition, we can take appropriate action or take the appropriate approach to discuss with the football club and ensuring they're complying with that condition. I don't think it's necessary for a gate. As far as I'm aware, there is one at the existing access, but not here. But it will be for the football club to control. But if committee thought that was a significant issue of likely infiltration outside of those hours, then that could be something that could be considered by condition. Thank you, Chairman.
Thank you, Madam Chairman. I just wanted to be cleared up. That's all.
Okay, thank you. Councillor Ward.
Thank you, Madam Chairman. This is the second application in succession tonight where we're kind of making a decision with a gun to our head. None of us want, or at least I can't speak for everybody, but I don't think any of us want the football club to fold, be thrown out, or whatever. But I have friends in Mead Lane, and the thought of 44 cars, which we're now told is an absolute necessity, pounding up and down there every match day, I really find quite difficult. And I have great sympathy with the football club as it appears that we, this council, have effectively removed their parking and put them in this very difficult situation, which I think is highly regrettable. The 3 year thing tying in with their changing rooms, I'm uncomfortable with, but I think probably we do have to go along with it. I get the sense from the officers' answers that at the end of 3 years they are not going to be able to use the Memorial Hall again, so I'm sure in 3 years' time we'll have an application to make this permanent. I would just say, when one of the public speakers was speaking, they mentioned coaches, and my ears pricked up, and I thought, what a wonderful idea, until I found out they were actually little men in their own cars rather than actual buses. But I wonder if there would be a possibility of just having 2 coach loads going down there and obviating the need for this parking. That's all. Thank you, Madam Chairman.
I'm not sure that's going to be much of an improvement for residents, but does any other councillor want to speak before I ask Councillor Hyman to come back? Well, I really meant a new councillor, so I'll take you after I've taken Councillor Hyman. Councillor Hyman?
Thank you. I take on board the reasons that have been given in terms of the car parking. I'm now in two minds. I haven't had an answer to the issue of whether appropriation of the land for planning purposes is going to be taken alongside this as another decision that we need to make in order for this to be regularised. I just wonder whether I could have an answer to that, please.
Officers, has anyone got an answer to Councillor Hyman?
Yeah, Councillor Hyman's asking a question about appropriation of land. Land that the council holds has to be held for a reason. That's a property law matter. I'm not a property lawyer, so I can't advise. But considering this is retrospective and it's already there, that matter seems to have already bolted, so to speak. So I can't advise on property law matters. It's outside of my remit. But Councillor Hyman's right. There has to be appropriation of land for planning purposes. You would need to speak to the property lawyers, Councillor, if you have concerns about this appropriation as such. Thank you.
Thank you. Councillor MacLeod?
Thank you, Chairman. I just wanted to come back on what Peter said about the car parking in the changing rooms. There's no reason why the car parking and the changing room has to be beside each other. In fact,
Let me just stop you. There is, Peter read out the rules, and I think one of the public speakers mentioned it as well.
Well, I've got the rule in front of me. The rule is that there should be adequate car parking facilities on or adjacent to the ground. Car parking within the ground may not be acceptable. the car parking can be anywhere, actually. It doesn't have to be adjacent to the changing rooms. And the car parking at the Memorial Hall would be totally acceptable, and I still don't understand why this has to go on for 3 years. I don't see what's changed at the Memorial Hall, that you can go back to the previous arrangement of car parking there.
Do you want the office to come back? I have a feeling it's one of those things we're going to have to leave hanging. You're going to have to make your decision, Councillor MacLeod, but if one of the officers has got an answer.
Thank you, Chairman. I've got nothing I can really add to what I've previously said. That the Memorial Hall now has different uses. It needs to accommodate parking for those uses. You've then got a football club next door which needs to have its own provision. Car parking provision for both is needed. So you're going to need 2 parking spaces to serve 2 different uses. And the temporary nature is the reasons I've set out. Thank you, Chairman.
I think unless you've anything new, I'd quite like to move to the recommendation. Councillor Leo?
I do have something new, Chairman. I feel it's with response to Councillor Hyman's point, appropriation of land. I do have very recent experience of that with the borough on council-owned land in my ward. And the way that it has been dealt with is that we have gone to planning. Planning is either approved or not in accordance with his recommendation. When it comes to the appropriation of the land, that's a separate issue. And actually that will need to be addressed, and it probably would need to take guidance from you at a later stage, but that will not affect the planning decision today, and it hasn't affected it in the past, which has been legitimate, and we've had to go to Secretary of State for appropriation, which is a separate issue. So I'm not a lawyer, but that's the experience I've had so far. Thank you, Chair.
Thank you, Councillor Malaya. That's most helpful, so that the 2 things are separate and it's not part of what we're looking at this evening. Can I just go back to the wording of the additional condition 7? Is that the best of all possible wording?
If I can actually recommend that that's changed slightly, if we remove 3 words from the first line so that it actually reads, the use hereby permitted shall not be used other than for purposes ancillary to Farnham Town Football Club and not for any commercial purposes whatsoever. So I'm removing the additional for any use because it really repeats what's in the beginning of the condition. Thank you.
Right, is the committee happy that we can move to the recommendation now? So there is a revised recommendation on the update sheet. That permission be granted, subject to the conditions 1 to 6, the informatives 1 to 4, which are all in the agenda report, and the additional condition 7, which we've just amended, or Louise has just amended, at Mr. Hyman's request. Can I see all those in favour, please, of that recommendation?
1, 2, 3, 4, 5, 6.
And those against that recommendation?
1.
And any abstentions?
1.
Thank you very much. Moving on to the third item, which again is open to public speaking. And if you thought we've been between a rock and a hard place all evening, we're very comfortable in the same position again. Yes, do have yourself. So moving on, this is WA 2017-0229, the erection of a dwelling and associated works, which is a revision of a previous application, WA 2016-1528, at land adjoining 34 Three Stars Road in Farnham. And is this Rachel who's going to introduce this for us?
Yes, it is. Thank you, Chairman. To take you through the application, you'll see the location plan outlined for you on the screen. So get this mouse working for you. You'll see the actual application site is outlined in black, and you've got the marker just here. You'll see it's at the end of the cul-de-sac known as Three Stars Road. And there's a public footpath which runs to the south of the site. Turning now to the aerial view, you'll see it comprises an open grass area sitting next to, at the end of a row of residential development. A quick reference to the site immediately to the north. You may recall this being the subject of an application debated, and there is permission on that site for a dwelling there, which hasn't progressed that much in terms of construction, but you'll see there are construction gates and fencing around that site at the moment, so that'll be a subject, is a material consideration to this application as well. Turning now to the site photographs. On the top right of the screen, photo number 1. This is the existing entrance into the site. You'll see the low 5-bar gate there. and you'll see it's a grassed area which slopes gently away from the entrance. Number 2 is just set further within the site. You'll get a better appreciation there of the gradient. You'll see there's low informal fencing around the site. There's a small existing shed on site just here. Some further site photographs here. Firstly, on the top right of the screen, this is the immediate neighbour to the application site, number 34 Freestyles Road. That's the side elevation facing on just here. And number 2, this is looking to the immediately north of the application site and the other neighbouring property. These photographs give you a better image of the street scene. Number 1, this is looking back along the cul-de-sac of Freestyles Road and the existing residential development there. Just on the very bottom left of the screen, that's the entrance to number 34 and the application site here. You'll see that on the northern side of Freestyles Road, primarily 2-storey dwellings on that side. What you can't quite see from this image, but on the southern side where the application site is, it's much more characterised by a single storey, both bungalows and chalet bungalows on that side. Number 2, the photo just here, you'll see these are the construction sort of hoardings associated with that development immediately north of the site for the erection of 1 dwelling. And you'll also see, looking towards the open fields, it's number 2 just here, east of the application site. Turning to the proposed block plan and the proposal itself. Here again you'll see the outline of that recently approved dwelling referenced. The proposal itself is for a 4-bedroom dwelling with a sort of linked garage, parking and turning area. The proposed new dwelling just here, proposed garage and the proposed driveway of parking to the front. Here we've got a comparison of the proposed block plan and the appeal scheme. On this application site there was a previous scheme granted on appeal, and I've got that compared in blue just here. That was for a 2-storey development, or a larger first floor element anyway, on that scheme. In terms of the actual footprint and block plan you can see before you, the footprint is increased at the ground floor level, and that's increased from 211 to about 311 square metres. However, it's broadly of a similar siting and position to the appeal scheme. Here you'll see the proposed street scene, and that's on the top you'll see the current proposal. This dashed line here shows you the outline of the appeal scheme, so here you can see that actually the overall height and the eaves are reduced from that previously allowed on appeal. And for a better point of comparison, you've also got the allowed appeal street scene just below. You'll see that's much more of a 2-storey development than what's proposed before you tonight. And particularly Lee's height, you'll notice quite a key difference there between the two. In measurement-wise, the ridge height is reduced by 0.8 metres and the eaves reduced from sort of 3.9 to 2.2 metres. So, whilst there is some first floor accommodation proposed, that's focused on one side, and you'll see it's predominantly single storey. This is the ground floor plans. You'll see here the points I've mentioned. The majority of the accommodation is spread over the ground floor with a small element at first floor level as well. Take you through the determining issues for the application, starting with the matters of principle and technical opinion. The principle of development has been established by the granting of the appeal scheme on the site relating to that larger dwelling. The proposal would make a modest contribution to the housing supply of 1 dwelling within what's been found to be a sustainable location in that appeal scheme. The proposal, subject to the completion of an appropriate legal agreement in respect to the SPA, the effect on the SPA would therefore be mitigated once that's complete. And you'll see that reflected within recommendation A on your agenda. Turning to the matters of judgment, They are the impact on the countryside behind the green belt, the area of great landscape value and visual amenity. In that regard, there will be some harm to visual amenity through the introduction of built form on what is an otherwise open site. However, it's important to note that this impact would be less than that under the approved appeals scheme. In respect of impact on residential amenity, subject to appropriate conditions to protect privacy, the proposal would be acceptable in that regard. The recommendation, or recommendation A, is therefore that permission be granted subject to the completion of an appropriate legal agreement in respect of the SPA by the 7th of November 2017 and subject to conditions. Recommendation A, in the event that that legal agreement is not completed, is that permission be refused. Thank you.
Thank you, Rachel. And we do have one speaker on this, Mrs. Bell, who is an objector to the scheme. Thank you, Mrs. Bell, and you two have 4 minutes from when you start.
Good evening, Chairman and Councillors. After the planning meeting and the unanimous refusal by the councillors at the Western Planning Committee, decision notice 28th of October 2016, I am sad to be back here today after the allowing of the appeal by the Planning Inspectorate, this time to discuss the second plan submitted for this plot for a chalet bungalow, especially as the appeal was granted only a couple of days before the neighbourhood plan referendum, this being overwhelmingly supported by 82% of local people who clearly wish to protect irreplaceable countryside. Even though the neighbourhood plan is not yet firmly established, I have to question the ethics of those involved in ignoring its intention, particularly as mention is made to the fact that this land is located in AGLV and outside of the BUAB, and that this development would erode the open and undeveloped character and appearance of the area. To be honest, it is my opinion that the council should stand up for their convictions and those of the local people and challenge this ruling. Ample reasons for this are given in the report. But since it seems they will not do so, it is now the responsibility of the planning department and the councillors to ensure that whatever is built on this plot is the best that it can possibly be, that it fits into the countryside well, does not overpower the other properties on the south side of Three Stars Road, or encourage a rush of applications to turn bungalows into houses, citing precedent, and that it enhances as much as possible the area rather than detracts from what is still classified as within the AGLV. The plan put forward has struggled, trying to fit what is essentially a house alongside a row of bungalows, and in an effort to maintain conformity of roof levels will have to dig down into the ground for quite some considerable way, making the front of the house appear half buried. This will severely detract from the aesthetics of the street scene, necessitating huge earthworks, and this is not adequately demonstrated by the submitted plans. It is noted that in his report the Appeals Inspector has pinpointed that a ground levels topography study should be a pre-commencement condition. What will happen if this proves the development unachievable in its current form? Should this not be provided prior to approval of this planning application? The absence of a topography report was brought to the attention of the applicant a long time ago, but as yet he has still not produced one. The applicant himself has admitted that the development would be obtrusive and has suggested strategic planting to minimise its impact. Indeed, it will be in clear sight of all nearby footpaths. The councillors may not be able to block this development, but must do their best to ensure that strict guidelines are implemented regarding design, materials, strategic planting and any other tools at their disposal. And also, considering the huge size of this proposal, that any permitted development rights should be removed. If any or all of these points are doubtful, then this plan should be refused until satisfactory answers are provided. If planning applications such as these are continually presented and approved on what seems to be an anything-goes basis, then I have great fear for the future of our countryside, where common sense and responsibility seem to be lacking. Thank you.
Thank you, Mrs. Bell. Some very interesting points there that I think we'll mull over in our debate. Thank you very much. Councillors. Councillor Hyman?
Thank you, Chairman. I don't know that we're going to need to say an awful lot because it's been covered extremely well by Mrs. Bell. I'm not going to repeat the points she made because they all stand up on their own, and I agree with her absolutely on, I think, every single point that's been made. Can you take us back to the determining issues slide, please? Because that's what we've got in front of us to make the decision on. My concerns here, if I just run through those, the principle of development we're being told has been established, but I think all members of this committee are aware that it's been confirmed to us that the principle from the Habitats Directive, which also applies to EIA, though this isn't EIA development, does apply. And therefore we can't, and that's a catch-all principle, where there is new information or a change of policy or whatever, then we cannot establish a principle of development because of that overriding legislation. Housing land supply.
I'll stop you there and get clarification. Is that true, Dan? Because we might as well all go home if it is.
Currently reading the previous appeal decision, that was all, because it's not appended to the actual report before you this evening.
It's the question of the principle of development. The fact that this has been allowed on appeal, has that set that, and is it lawful again?
That's the key thing, I think, Chair, and obviously I'm put in a position again where Councillor Hyman, if you were to come across to legal services and have an informed chat, we could probably sort this issue out once and for all. But essentially, the inspector would have had the same precautionary principle in mind, and he decided to permit the development. So the inspector, being a learned inspector appointed by the Secretary of State, obviously in tune with the submission you're making this evening, would have, of course, turned his mind to those particular issues and principles. He decided to grant permission. So essentially the decision has been made by the inspector in terms of that particular point. He's also considered, I'm looking at paragraph 15 of his particular decision, he says, and this is a quote because it's not before you members, I think it's only right you hear this, from the evidence before me, the site lies within 5k of the zone of influence for the Thames Basin Heath Special Protection Area. Policy D5 of the local plan, together with the Waverley Borough Council Thames Basin Heath's Special Protection Area Avoidance Strategy, outlines that mitigation is required for new residential development within the 5k influence zone. The need for mitigation is not disputed by the appellant. And he goes on to look at the legal agreement, the Section 106, which overcomes the harm to the Thames Basin Heath. And the inspector said that essentially he has no reason to disagree that there is appropriate level of mitigation in accordance with the avoidance strategy. To conclude, and taking that in the round, it seems to me that the Section 106 agreement and the unilateral undertaking given on the appeal scheme was fine. It met the policy required of policy D5 of the local plan, and it complied with the avoidance strategy, and the legal agreement is fine. Going back to the original point Councillor Hyman made, yes, it is a factor. It's always a factor. We have to comply with regulations. We have to comply with the law. Habitats directives, EIA issues are a matter of law. And yes, that is always there in the background. Also there is decisions in accordance with the development plan and any other material considerations. And your planning officers are saying that in terms of habitat regulations, this matter is fine. The inspector thought it was fine. So the point is somewhat academic, because I agree with Councillor Hyman, totally. Those regulations and those laws and those principles are sound. Councillor Hyman is making no error of judgment or of interpretation of the law. But the inspector thought it was fine. He didn't enter with that debate. He would have been the first to actually pull this up if it didn't meet any regulations or requirements in the law. The fact is, it went to merits, and by merits, he looked at the planning reasons, and he looked at the harm, and he looked at the policies, and he looked at the other material considerations. He didn't essentially pull this development up and say, it doesn't comply with the habitats regulations, so I need not enter into this particular debate here that Councillor Hyman raises. So it's a fair point, it's a crucial point, and one we are continually drawn to. But essentially, the inspector thought it was sound. He went and looked at the planning merits. The application is before you. You have to determine the planning merits, indeed, alongside the principles that Councillor Hyman makes.
So, in brief, the principle of development has been. Could you turn your mic on? Sorry, has been met. So we are looking here again at a principle development that has already been established, and we are really, I think, as Mrs. Bell was suggesting, that we don't have a great deal of flexibility here, but we can mitigate as much of the visual harm and the impact on the countryside in this area as we can, if we decide to go along with the principle of development established by the previous inspector. Councillor Ward.
Thank you, Madam Chairman. I'm just trying to see something from my pretty diagram on my machine, and I can't quite make it out or read it. Could officers tell me how far this building is from the boundary of the adjacent property, please?
.5 metres.
Thank you very much. I understood this council had a 3 metre minimum strong guideline. Could someone tell me why we're so happy with this one, which seems to contradict that?
Thank you, Chairman. The 3 metre guideline you're referring to relates to residential extensions and extensions to existing properties that are 2-storey beyond the rear elevation of a property. And their guidelines or advice that we should take into account. They are a consideration, and you'll see we list them as a consideration as the SPD. But this is a single-storey building effectively, and it doesn't relate to a 2-storey rear projection, so that's not effectively enforced. And you also look at the block plan that's before you, that it doesn't project beyond, well, there's a slight outshot on the neighbouring property, but it doesn't actually project beyond the rear of the neighbouring property. And again, it is set off the boundary by 2.5 metres, and the roof also pitches away from that boundary as well, therefore limiting the likely impact on the neighbouring property. So hopefully that's helpful. Thank you, Chairman.
Councillor Ward, have you? Thank you. Any other councillors wish to speak on this application? Can we just go back to Mrs. Bell's point about conditions that we could add if we were going to grant? I mean, how much flexibility do we have on landscaping materials, all the matters that Mrs. Bell raised?
Thank you, Chairman. What we've taken approach, of course, the committee has the ability to apply those conditions if they considered reasonable. What we've done is effectively applied the same conditions as the inspector previously, and in addition to sort of hours of use or hours of construction, so we've added extra there. If members feel a detailed landscaping scheme is appropriate, that could be applied. But with the consented scheme, it wasn't considered necessary for a single residential unit. This is obviously a smaller unit to that as well. So it's down for members to decide on that basis. But of course, if they consider it appropriate, they could add that condition. The other one was also related to permitted development. Again, it would be down to members to decide. The inspector didn't consider it necessary on the larger building. It's a large plot. There is sufficient space to accommodate extensions under permitted development. I don't think it would have a greater impact on the wider countryside in terms of the form of development that could be carried out to permitted development. But again, that's for members if they could see appropriate, and we could word those.
I quite take the point raised on permitted development, but this house, although it is smaller, has a much larger footprint. And therefore permitted development will be more obtrusive. So I have a lot of sympathy with the point raised by the public speaker and would be in support of them being removed.
Can we achieve that, Peter?
Thank you, Chairman. Yes, if members, we can certainly draft a condition withdrawing permitted development rights. What I would just ask for clarification on is you're seeking to remove all permitted development rights under Part 1, of the general permitted development, or are you just looking for extensions to properties? Because you could remove that, and they would need effectively planning permission to construct a shed if you removed everything. So you may want to consider that you might just remove permitted development rights for extensions or alterations to the roof. Thank you, Chairman.
Would the committee feel happier if we put a condition in like that, removing the permitted development rights on extensions and development into the roof? Yes, we can do that, can we? And I would be happy with some forward landscaping in this particular site. I don't know if other members would back me on that one, so that we could see details of the proposed landscaping. Is that possible as well?
Thank you, Chairman. My position is still on the inspector didn't consider it necessary, and it might be a bit more onerous given that it's a smaller scale development, but that's judgment for members. But we can certainly apply the permitted development allowances, and I suggest it's removing classes A and B of Part 1 of the General Permitted Development Order, and they'll be the ones we would apply in a condition. Thank you, Chairman.
So can I just clarify? So basically, yeah, I've got you, Councillor. So landscaping is really a no-no, basically, you're saying?
That's just my view based on what the inspector concluded, but it is within, it's down to you, but my advice sort of stands on that it would be over above.
Thank you, Peter. Councillor Lear?
Thank you, Chairman. I think it's arguable that because of the footprint size and the fact it's closer to the boundaries, that actually a landscaping order could be advantageous in this instance, and I think it could be demonstrated as such.
Would that be reasonable?
Yes, we can apply that, and it would be purely soft landscaping you're looking for soft and hard landscaping. I mean, it's basically planting, I think, you're looking for, isn't it? So we could look for a planting scheme. Thank you, Chairman.
Right, members, does anyone else wish to speak, or can we move to the recommendation? So, the recommendation is that permission be granted, subject to the... I take it this is the only one I haven't got an update. Oh, yeah. Subject to the completion of an appropriate legal agreement in respect to the SPA by the 7th of the 11th, 2017, and subject to conditions 1 to 6 as set out in the agenda, plus additional conditions 7 and 8. 7 to remove the permitted development rights A and B, and 8 to ask for details of soft landscaping. Is that what the committee has agreed? In that case, can I put that recommendation, please, that permission be granted with the 6 conditions listed in your agenda plus the 2 extra conditions? Can I see all those in favour, please?
That's 7.
And those against?
1. No.
And no abstentions. And I think we have a recommendation B, that in the event that the requirements of recommendation are not met, permission be refused for the long reason that you can see on page 95. Can I see all those in favour of that recommendation?
Unanimous.
Thank you very much. And finally, moving on to item B1, WA 270416, an application under Regulation 3 for the erection of a section of wall and demolition of an unlisted wall in a conservation area, Central Car Park, Victoria Road, Farnham. A bit different from some of the others. Rachel, you're going to introduce this.
Yes, thank you, Chairman. I'm sure it's a car park everyone knows quite well in the centre of Farnham. On the top right of the screen, you will see a photograph of the existing application site. This is looking towards Waverley News, the housing just opposite on the car park side of the wall. And what you see on screen is more or less the area subject of the application. On the bottom of your screen, the bottom right photograph, that's stood on the other side of the wall looking towards the car park. And there's also a location plan for you on screen. It's quite a small site area, it's just that precise area of wall subject of the application. Turning now to the proposed plans and aerial view. Just got one plan on here, as a proposal is to demolish and rebuild a bit of wall. That's the section highlighted in red just here. Bottom left of the screen, you'll see a close-up which will show you the area of wall to be replaced. And on the bottom right, you'll see an aerial view just showing a position in the car park just here. Take you straight to the determining issues for this application. The matters of principal and technical opinion are principle of development, archaeology and air quality. The site's in the town centre. The principle of development is acceptable in that location. Given its small-scale nature, there's considered to be no adverse impacts in respect of archaeology or air quality. The matters of judgment in this instance are the impact on visual amenity in a conservation area and the impact on residential amenity. Similarly, given its modest scale in comparison to the existing position, it's considered to be acceptable in terms of its visual appearance and impact on the conservation area. There'll be no change in sort of height or bulk over existing, and as such, no adverse impacts on residential amenity. The recommendation is therefore that permission be granted for the reasons set out in your agenda report. Thank you.
How nice to see a drawing that we could all do ourselves. Does anyone wish to comment on the wall? In that case, Councillor Hyman.
Only that it's in my ward, this is perfectly proper, and I don't think there's any reason for anyone to object to it.
Phew. I'm sure we're all greatly relieved that there's no reason to object to
Is this the first time everybody's agreed with me, ever?
Well, let's enjoy the moment. Councillor Story, do you really wish to speak?
Oh, absolutely. Yes. I think this is probably the most far-reaching decision we're making this evening. No, I'm just concerned about whether the new section of wall is going to stand out from the existing walls. I see in the report that modern bricks are going to be used, but colour matching as far as possible. I'm just wondering whether the existing bricks are capable of being recycled.
Do you have an answer for that one? They're fairly modern anyway, aren't they? They're in this particular bit of wall.
I think that's unlikely, Chairman, just because of for the demolition to take place, and we've got control of detail and colour. It will stand out because it will be a newly constructed wall, new mortar and things like that, but it will weather after time and fit in. So, thank you, Chairman.
I find with these small projects, it's not the bricks as such; it's the mortar. If they get that the right colour, it's far less intrusive than this, sort of bright white in amongst it, which rather highlights the fact that the brick is still not quite sort of as mature as the rest. But anyway, I think it's a small detail we can live with. So can we move to the recommendation on page 107 of your report that permission be granted subject to conditions 1 and 2. And the informatives 1 to 3 on page 108. Is that recommendation? Could I see all those in favour of granting permission?
That's unanimous.
Anyone against? A rare moment of harmony on which to finish the evening. Thank you very much, committee, and thank you, officers. It's been a long day.